Hello, this is Indian Polity series presented by me, Rahul Das. Here I am, and this lecture is about basic structure of the Constitution. So this is going to be a very important lecture and very exciting lecture. So let's start our discussion. So today's topics of discussion will be first of all some initial points to understand. So there are some initial points which we need to understand before actually going into the basic structure, and these points are Article 13 of the Constitution, then concept of judicial review, very important, the ninth schedule of the Constitution. So first of all, we will see what these points are all about. Then we will go into the second topic, which is how did the concept of basic structure emerge. So we will see here how did the basic concept of basic structure actually emerge in our constitution, and lastly we will see some of the elements and components of the basic structure. So let's start our discussion from our first topic. So some initial points to understand. First point is Article 13 of the Constitution. So what does Article 13 of the Constitution states? Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. So Article 13 clearly states that all laws will be void if they are inconsistent with the fundamental rights. It has been clearly stated in Article 13 of the Constitution. Now, the term law in Article 13 has been given a wide connotation so as to include the following. Number A, permanent laws enacted by the Parliament or the state legislatures. Number B, temporary laws like ordinances issued by the President or the state governors. C, statutory instruments in the nature of delegated legislation like order, bylaws, rule, regulation, or notification. And D, non-legislative sources of law, that is, custom or usage having the force of law. So these are the meanings of law which comes under Article 13. Then the second point is concept of judicial review. This is a very important concept. Judicial review refers to the power of the judiciary to interpret the Constitution and to declare any such law or order of the legislative and executive void if it finds them in conflict with any of the fundamental rights. So judicial review is the power given to the judiciary. So judiciary can interpret the Constitution and declare any such law or order or legislative and executive action void if the judiciary finds those orders and law in conflict with any of the fundamental rights. So no law, no executive order, or no legislation can be in conflict with fundamental rights. If they are in conflict with fundamental rights, then they can be declared void by the Supreme Court, according to this concept of judicial review. Then the second thing is this power has been conferred on the Supreme Court by Article 32 and on the High Courts by Article 226. So the Supreme Court have the power of judicial review, and this power has been given by Article 32, and High Courts also have the power of judicial review, and this power has been given to High Courts by Article 226. So this was concept of judicial review. Now the next point is ninth schedule of the Constitution. So what does ninth schedule of the Constitution says? Laws under ninth schedule are beyond the purview of judicial review, even though they violate fundamental rights enshrined under Part 3 of the Constitution. So all the laws which are placed under ninth schedule, they are beyond the purview of judicial review, and even though those laws violate fundamental rights. And as we know that fundamental rights are enshrined in Part 3 of the Constitution. So all the laws, even if they are in conflict with fundamental rights, but if they are placed in the ninth schedule of the Constitution, they cannot be challenged in the Supreme Court or High Courts. Then on the one hand, considerable power was given to legislature under Article 31B, and on the other hand, the power of judiciary was curtailed. So ninth schedule was related to Article 31B, and by inserting ninth schedule in the Constitution, considerable power has been given to the legislature. Legislature itself has given this power to themselves, and on the other hand, the power of judiciary, that is the power of judicial review, was curtailed. So this was about ninth schedule of the Constitution. Now these three initial points are very important to remember or to understand if we want to understand the basic structure of the Constitution. That is why I have inserted these initial points at the very beginning of the lecture. Now, coming to our main topic, which is basic structure. So, how did the concept of basic structure emerge? The concept of basic structure emerged to solve the issue of amendability of the fundamental rights by the parliament. So, this concept has emerged to solve the issue of amendability of fundamental rights, whether fundamental rights can be amended by the parliament or not. So in order to solve this issue, the concept of basic structure has emerged, and this can be illustrated by the series of following court cases. So these are very important court cases which we will discuss here. So the first case we will discuss is Shankari Prasad case of 1951. Now what happened in this case? In this case, the validity of the First Amendment Act 1951. So Constitution was firstly amended in 1951, and in this case the validity of the First Amendment Act was challenged. Now why was this amendment challenged? Because this amendment curtailed the right to property. So fundamental rights, earlier they used to have 7 fundamental rights, but right to property was eliminated from the fundamental rights by the First Amendment Act, and in this case, this First Amendment Act, which curtailed the right to property, was challenged in the Supreme Court, and the Supreme Court ruled that Parliament can amend the fundamental rights under Article 368. So Supreme Court ruled that Parliament has all the powers to amend the fundamental rights under Article 368, and it also said that the word law in Article 13 includes only ordinary laws and not the constitutional amendment acts, and thus any of the fundamental rights can be amended by constitutional amendment acts. So Supreme Court clearly stated that the word law in Article 13 includes only the ordinary laws and not the constitutional amendment acts. So if some fundamental rights are amended by constitutional amendment acts, then it will not be void. It will be constitutional. It will be legal. That is why Supreme Court ruled that Parliament can amend the fundamental rights under Article 368. And in this Shankari Prasad case, the constitutional validity of the First Amendment Act 1951 was challenged, but Supreme Court said that since this amendment was made by introducing constitutional amendment bill, that is why this amendment is valid and it cannot be challenged. Now the second court case we will discuss here is the Golaknath case of 1967. Now in this case, the constitutional validity of the 7th Amendment Act 1964, which inserted certain state acts in the 9th schedule, was challenged. So in this case, what happened was the 7th Amendment Act was challenged, which inserted certain state acts in the ninth schedule. So some state acts, some acts which has been made by the states, they were inserted in the ninth schedule in order to protect them from the purview of judicial review, and this was challenged in Golaknath case. Now the Supreme Court ruled that Parliament cannot take away any of the fundamental rights. So Supreme Court made opposite judgment from Shankari Prasad case. In this case, the Supreme Court ruled that Parliament cannot take away any of the fundamental rights. It said that a Constitutional Amendment Act is also a law within the meaning of Article 13 and hence would be void for violating any of the fundamental rights. So earlier in Shankari Prasad case, Supreme Court said that Constitutional Amendment Act is not a law according to Article 13. But in Golaknath case, Supreme Court ruled that Constitutional Amendment Act is also a law within the meaning of Article 13, and hence any Constitutional Amendment Act or law which is introduced to curtail any of the fundamental rights will be void. So Supreme Court said that it will be void for violating any of the fundamental rights. So completely different order was passed in Golaknath case. Now coming to our third case, which is not a case but it is an amendment act, 24th Amendment Act of 1971. This act amended Articles 13 and Article 368. So Parliament amended Articles 13 and Article 368, and it declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. So according to this Amendment Act, this Amendment Act declared that Parliament has the power to abridge or take away any of the fundamental rights under Article 368, any of the fundamental rights, and such an act will not be a law under the meaning of Article 13. So here clearly Parliament tried to reduce the power of judiciary, and they also tried to curtail the power of judicial review. They tried to snatch the power of judicial review from judiciary by introducing this Amendment Act in 1971. Now, what happened in Keshav Nanda Bharati case? This is a very important case. We will refer this case very often in our lectures. So, in this case, the Supreme Court upheld the validity of the 24th Amendment Act and stated that Parliament is empowered to take away any of the fundamental rights. So, Supreme Court said that okay, 24th Amendment Act is valid and Parliament is empowered to take away any of the fundamental rights. But the Supreme Court also laid down the new doctrine of basic structure of the Constitution. So, Supreme Court said that 24th Amendment Act is valid and Parliament is empowered to take away any of the fundamental rights, but they also laid down the new doctrine of basic structure of the Constitution. And the Supreme Court ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. So Supreme Court ruled that though 24th Amendment Act is valid and Parliament is empowered to take away any of the fundamental rights, but Parliament has no power to alter the basic structure of the Constitution. This means that Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. So those fundamental rights which forms a part of the basic structure of the Constitution cannot be abridged by the Parliament under Article 368. 8. So this was the ruling of Supreme Court in Keshav Nanda Bharati case, very historical ruling. And in this way, the concept of basic structure of the constitution came into existence. So it was in the Keshav Nanda Bharati case that the concept of basic structure of the constitution came in to existence. Now, our next topic of discussion is elements or components of the basic structure. So, what are some of the elements and components of the basic structure? Now, first of all, we should understand that the present position regarding basic structure is that the Parliament under Article 368 can amend any part of the Constitution, including the fundamental rights, but without affecting the basic structure of the Constitution. So, Parliament cannot affect the basic structure of the Constitution. They can amend any part of the Constitution. They can also amend fundamental rights, but they cannot affect basic structure of the Constitution. Now, from various judgments of the court, the following have emerged as basic structure of the Constitution. So, following are some of the basic structures of the following are some of the elements which form the basic structure of the Constitution. These are not all the elements. There are many elements, but I have tried to list some of the important elements of the basic structure, and these are as follows. Supremacy of the Constitution. So, supremacy of the Constitution forms the basic structure of the Constitution. It cannot be affected by the Parliament. Then sovereign, democratic and republican nature of Indian polity, and secular character of the Constitution. So our Constitution is secular, as we know, and this secular character of our Constitution cannot be affected by the Parliament. Then separation of powers between the legislature, the executive and the judiciary. We know that our Constitution provides separation of power between legislature, executive and judiciary, and this also forms a basic structure of the Constitution. Then federal character of the Constitution. Our Constitution has federal character, and those federal characters cannot be affected by the Parliament. Then unity and integrity of the nation. Judicial review, this is very important. So judicial review itself is a part of the basic structure of the Constitution, and it cannot be taken away by the Parliament. Then parliamentary system. In our country, we follow parliamentary system of government. This is also a basic structure of the Constitution. Then rule of law, principle of equality, free and fair elections. There should be free and fair elections. Then independence of judiciary. So judiciary is independent, and this also forms a basic structure of the Constitution. And there are many others. Many other elements that forms the basic structure of the Constitution, but I have tried to list some of the important ones. So this was about basic structure of the Constitution. I hope you understood the topic. So thank you, and you're also welcome to visit my Facebook page for other study materials on Indian polity. Have a nice day.